Morning everybody, welcome to our first webinar of 2018. We're going to be discussing this morning the Rangers tax case relating to EBTs and other recent developments, legal and tax issues for trustees. We're hoping to be talking for between 40 and 45 minutes, and there will be the opportunity to send questions through after the end of the webinar. So starting with an overview of the Rangers case and looking at the background, we'll then be talking about the application of the decision to wider structures, the wider landscape. There have been quite a lot of developments which are relevant to employee trusts in particular, the new trust registration service, employee ownership trusts, the impact of the Roadchef case. It's now got quite a long history, but it's still very relevant to the ongoing administration of trusts, and the importance of independence. Looking first at the Rangers case. For those of you who don't know, it was a case concerning an EBT, an employee benefit trust, operated by the Murray Group for senior executives and footballers. So although it's referred to generically as the Rangers case, the actual court reference refers to the Murray Group as being the taxpayer, which has caused some confusion on occasion. I think it's worth just having the quote there from the decision in the Supreme Court. The words that we've set out on the slide are the opening words in the report. I shall read them because I think they are quite significant as an indication of the way that the courts view these sorts of arrangements. So Lord Hodge started by saying that this appeal concerns a tax avoidance scheme by which employers paid remuneration to their employees through an employees' remuneration trust. Now, I remember when I read that, before knowing what the decision in the case was, I decided that I knew just from reading that what the decision was, because it was clear that it was viewed, to repeat some of the words, it's a tax avoidance scheme, black mark, by which employers paid remuneration to their employees through an employees' remuneration trust. So the theme that we have there is of tax avoidance, where there is remuneration. The courts are not accepting that it's a contribution to a discretionary trust, the classic analysis that was held with employee benefit trusts when they were set up and operated. What did the court decide? What did they find? Well, the key point was that income tax and NICs are payable on remuneration, whether or not that remuneration is paid to an employee or a third party. That by itself wasn't particularly controversial. There are several employment tax cases of a long standing where that has been the established position, and clearly if you or I are employees of a company and we have a contractual entitlement to salary and we request that instead of being paid into our bank account it's paid to somebody else, that is clearly taxable in our hands. No one would doubt that. And what's happening in this case is that that principle is being extended through the application of the redirection approach to include payments made into employee benefit trusts. The interesting development, or one of the interesting developments, is that the fact that the contributions to the trust were voluntary. That was found as a matter of fact in the court hearing. And what the Supreme Court said was that this was irrelevant so long as there was a sum of money given in respect of the employee's work as an employee. The risk that the trustees would not exercise their discretionary powers did not alter the nature of the payment to the trustee. And you can see there that that begins to demonstrate that the court did adopt a radically different approach to analysing these sorts of arrangements compared with the view and expectations and understanding that had applied beforehand. The basic proposition was that when payments were made into a discretionary trust, at that point, the employee did not have any entitlement to receive the payment. The trustees were exercising their discretion, and that was sufficient to ensure that there was no receipt of taxable earnings. And what the courts were saying here is that, in effect, the advisors and to a larger extent HMRC had been considering the wrong point. It wasn't the question of how the payments were treated within the trust or on receipt, but on payment by the employer. So what are the implications for trustees? I mean, it might be that some trustees will look at this and say, well, it doesn't really affect us. We've received the money, we've applied in accordance with the trust fund, trust deed. Yes, this has a major impact for our beneficiaries, but it doesn't actually affect our position. Well, I think the first point is that this is a decision reached by the UK Supreme Court, and as a consequence, the conclusion and the reasoning, that is the state of the law. It is a conclusive tax analysis of contributions to EBTs. Now, that does not mean that all EBTs will be taxed in the same way, and it is to a large extent fact dependent. But the point there is that whereas previously we might have expected a finding of law based on particular facts or a particular approach which might be differentiated, it's much more fundamental that the approach being taken here is a statement of what the law is in relation to the funding of EBTs and other similar trusts. And I think it would be difficult to identify fact patterns which allow cases to be distinguished. And this is contrary to what I had expected looking back over the history of the decisions in the Rangers case, the initial decision before the first tier tribunal, the decisions in the subsequent levels of the appeal. I thought it was going to be difficult for the earlier decisions to be overturned because they were so clear on their findings of fact. But the Supreme Court succeeded in finding a basis promoted by counsel for HMRC, Julian Ghosh QC, which allowed them to reach a conclusion based on a different analysis of the law and conclude that the earlier tribunals had in effect got the law wrong. Now, having said that, looking at it from the trustee's perspective and thinking about the impact on trust assets, the ability of HMRC to raise assessments in respect of historic contributions will still be limited. So the main point being that a time limit may have passed or a settlement may have been reached with HMRC in respect of previous tax liabilities. Given the time that has elapsed since EBTs were first set up and operated, the time that's elapsed since disguised remuneration came in 2011/2012, and the extent of the settlements that have been reached, that means that the practical immediate impact of the decision will be fairly limited. There are many trusts have settled, many other cases where they've gone out of time, but equally there are still a substantial number of cases which have not been addressed by the revenue, and where there is therefore the potentiality for the revenue to go and raise assessments for past years. So there is an immediate potential implication there depending upon the state of the tax profile of the trust in the particular case. However, where that's not the case, i.e. where there has been no settlement, tax and NICs may now be due. So the trustees in those circumstances should check the terms of the trust to determine whether there's a liability which could be claimed by way of an indemnity against the trust assets. That will be fact specific, trust deed specific. It's important to be looking at the specifics of the trust, always in trust law driven by what the terms of the trust deed say. There is the risk of HMRC, where no settlement has been reached, issuing follower notices under the advanced payment notices or APN legislation. And where follower notices are issued, then the obligation will be to pay the tax which is claimed and then consider being able to appeal against it rather than the other way around. So that is a fairly draconian piece of legislation. It is clear that the revenue are thinking of applying it to EBT cases which have not settled. And consideration should be given to writing to beneficiaries to inform them of the decision and its potential consequences, because we now know what the tax treatment is, and we didn't know that until the case was decided. So there are a number of issues there for trustees to think about on a fairly immediate basis. One of the features of the decision is the clarification that due to tax being due on the contributions, employment tax should not have arisen under the general employment tax rules on the subsequent distributions or benefits. Now, that does not mean that if tax has not been paid, there may not be liabilities under other relevant provisions. So there might still be discouraged remuneration charges, and therefore, if you are a trustee looking at assets held within an employee trust today where no settlement has been reached, the last thing I want to do is to give the impression that you can simply pay it out without paying tax or withholding PAYE or accounting for NICs. That's definitely not the case because of the DR rules. But nevertheless, there may be scope in particular circumstances, probably where the DR rules did not apply, the discouraged remuneration rules did not apply for some reason, for tax to be recovered by beneficiaries. The other area that we need to think about quite carefully is the ability of HMRC to seek to apply the decision more widely to other forms of employment-related trusts. I do think that the impact of this decision will be much broader than simply EBTs. It will go certainly to other types of trusts, maybe other types of arrangement as well. So we would see a direct application to EFRBSs, or what used to be called FERBs, which are usually set up in the form of, broadly speaking, an employee benefit trust. There's a lot of difficulty with terminology in this area. I'm using the phrase employee benefit trust here to mean any employee trust which is not a share-based trust established for employees, and an EFRBS would fall within that definition. We've seen cases where the reasoning has been applied already, and we refer to one on the slide there, Landed and HMRC, which was the appeal in that case was heard after the Rangers decision, and essentially the court just followed the decision in the Rangers case. And there is the potential for the Rangers case to be applied widely to other forms of employment-related trusts, and I'm not going to attempt to summarize those sorts that that exist. There are a wide variety, although most advisors and most trustees will come upon a limited range. It is surprising how many types of employee trusts are out there. When the Revenue were first reviewing EBTs, I think they identified something like 80 odd different types of trusts, which they were then trying to deal with and categorize and manage. So there are a lot of different types of trusts which could be affected. How does this then impact on the wider landscape? Well, I think that any tax advisor in this area who has been around for a long time will have seen the increasing momentum that's built up to counteract what's seen as tax planning, tax avoidance, tax evasion. Looking at the terminology is quite interesting because I deliberately use the phrase tax evasion there and use that in the same sentence as tax avoidance. And the reason for that is that there is in law a clear distinction between tax avoidance and tax evasion. Dennis Healy, when he was Chancellor of the Exchequer, defined the difference as being the difference was measured by the width of the prison wall. And what he meant by that was that tax evasion was illegal, criminal, was sent to jail. Tax avoidance wasn't, and that is still the case legally. But we've seen that distinction being blurred. And I think to some extent that is the case with the Rangers case, but it's more so with all of the subsequent legislation which has been introduced to try to discourage tax avoidance of one form or another. And that needs to be seen in the context not of just of the legal position, but also of the political position, and all of the focus through disclosures by the media in the context of the Panama Papers and more recently the Paradise Papers, and the heat which can be generated by that sort of publicity, all goes towards creating the environment where there is a very low tolerance of activity which is seen as tax avoidance, even if that is perfectly legal. And I think that as trustees, it will be important to remember that when assessing proposals put to trustees, either for new trusts or uses of existing trusts, particularly given the adverse view that the Revenue in the UK, and I suspect in other overseas jurisdictions as well, have of employee type trusts, so offshore trusts generally, particularly those related to employment. We've also got the increasing transparency. The government is intending to spearhead international efforts to improve tax transparency, and we've already seen rules with the Common Reporting Standard and other measures which are consistent with that. And I don't think, in principle, many people would argue against the merits of tax transparency, but what that means in practice is more concerning. And I think that will be an area which I know from talking to trustees has caused a lot of work, a lot of difficulty for trustees over the recent years. And my expectation is that it will continue to do so. It was interesting to note that in the UK budget 2017, there were 18 separate measures which were announced to tackle avoidance, evasion and non-compliance, with a view to raising a further £4.8 billion between now and the tax year 22-23. In the context of the size of the UK economy and some of the challenges to the UK economy, 4.8 billion may not sound like such a big number, but what it is doing is demonstrating the continued focus on trying to reduce the so-called tax gap. I say so-called because I'm never quite sure whether there's a clarity on definition of what that means when talked about by politicians and the press. But I think what it illustrates also is that my take on what's been happening, or one of the interpretations of what's been happening, is there's been the ability to raise significant extra revenue from changes to law and changes in revenue practice to recover tax which has previously not been recovered. And that will actually get harder for the revenue as time goes by, because a lot of the low-hanging fruit, to use that phrase, have already been picked. And to some extent, the EBT area is one of those. And it could be argued that the revenue which the revenue will be able to obtain from EBTs has probably now been substantially exhausted. But because of the political pressures, because of the investments being made by the government in the revenue in this area, there is likely to be continuing pressure to continue to raise additional amounts, additional funds. And the risk for taxpayers and for trustees and for anyone involved with the revenue is that that will lead and encourage the revenue to become more aggressive, more pushy, and continue to find other areas to raise tax where that has not previously occurred. So I think there's a warning there for not just trustees, but all taxpayers in terms of likely future developments. Moving away from that area and to talk about the Trust Registration Service, and this is a new development in the UK. We're talking here about setting up a new system for trying to demonstrate tax transparency, and the requirement is that any taxable relevant trust must be registered with HMRC via the online tax registration service. And what that means is that in many ways, much of this is not new, but trustees of taxable relevant trusts must maintain accurate and up-to-date records of all beneficial owners and potential beneficiaries of the trust. There's a deadline for existing trusts, which has now been extended to the 5th of March 2018, and a deadline for new trusts, which has just passed, for trusts incurring a tax liability for the first time in 2016-17 of the 5th of January. The extent and the operation of the TRS is still subject to discussion, and I think it will take some time for it to settle down and to become clear exactly how it's going to work in practice, and to see what difficulties there are with the new system. But it's certainly an area where trustees which have an existing UK tax liability, or indeed incur a liability in future, will need to be cognizant of the need to complete the reporting, to complete the registration under the new system. Moving on to something which in many ways might be seen as a more cheerful topic, and by more cheerful what I mean is that it's an area which is more positive. It's from a trustee's point of view, it offers the opportunity for new trusts, new growth, new areas of activity, which is the Employee Ownership Trust, EOT. And this was legislation which was introduced in 2014 following representations made during the coalition government. It is intended to replicate the broad structure for the ownership of companies seen with John Lewis. And the intent with the legislation was to provide tax reliefs on the sale of a majority stake, 51% plus, to an employee ownership trust on condition that the assets are held for the benefit of employees as a whole. And that is, broadly speaking, what's happened with John Lewis. People discuss John Lewis in terms of being a partnership. It's not a partnership. People discuss John Lewis in terms of employee ownership, as in direct employee ownership, and for the most part, it isn't. What John Lewis is the company set up to employee trust, which was established in the 1930s. And the intention to encourage other businesses to operate through a similar regime was an explicit objective of the EOT legislation. And this is intended to be achieved through the provision of generous tax reliefs. The main one being that the sale of shares to a qualifying EOT is free from capital gains tax. The payments from the company to the trust to fund the sale are tax-free. And where the structure is in place, there is the ability for the company to pay annual bonuses, discretionary bonuses, in addition to previous remuneration. This is not a salary sacrifice or bonus sacrifice, of up to £3,600 each year, free from income tax. Note, that's free from income tax. It's not free from national insurance contributions. And also the payment is made from the company and not from the trust. The EOT legislation does not prevent the company operating tax advantage share schemes. So you could still have a CSOP, company share ownership share option plan. You could still have Save As You Earn, SAYE. You could still have EMI. You can still have SIP, provided that that does not result in the ownership of the company falling down below the 51% threshold. What are the implications for trustees? I think this is actually quite a big issue. We've only got 3 bullet points on the slide, but I could spend quite a long time talking about it, because owning or being the trustee of an EOT which owns at least 51% of the company is a completely different proposition from owning 5% or less, 5, 10%, 1%, a small minority holding. The reason being that as a small minority holding, the trustees have the same rights as other shareholders, but those rights are limited and the influence is limited. And what that does is that while operating an employee share ownership trust, owning that sort of traditional small percentage of the share capital, certainly imposes significant obligations on trustees, significant responsibilities. It's moving to a different level when you are talking about owning 51% or more of the company. What that means is that the trustees have the ability, as a matter of law, to make fundamental decisions regarding the future of that company. And that places a much greater responsibility. You as trustees can have decisions which will, do we sell the company or don't we? What happens if the company is doing badly? Do we have to step in and, despite the fact that we are an employee trustee, just make a decision to dismiss senior executives because they're not performing, dismiss people who are beneficiaries of the trust? It's not hard to see that the trustees can quite easily get into quite difficult scenarios. And what that implies is that there is a requirement for trustees of EOTs to adopt a much more active role in decision-making processes. There's much more thought required as to whether trustees have the relevant skills to make the decisions that they're required to make. And to the extent that they don't, the extent to which they should seek outside advice, how much that advice will cost. The trustees here are very much the owners of the company, in the sense of owning the majority stake. There's also a point there that corporate governance requires careful consideration. An EOT is not meant to be set up as a sort of orphaned-owned company. The intention is that the trustees will be represented. It's an employee ownership company, so it's an employee ownership trust in order to establish an employee-owned company. And therefore, there's an expectation that employees will be able to have their say. What does that mean? It doesn't mean that what the employees want will necessarily go. There will be a conflict between, or potential conflict between, demands by the employee group to pursue a particular course of action which the trustees and the senior executives might not think is right for the company. How is that going to be regulated? How are the views of employees going to be obtained in a way which does not dictate to the trustees the course of action to be taken, but gives due credence to their views? And that will be different from company to company. There will be an importance to establish a proper corporate governance structure. It might be that there'll be an employee council. It might be that there'll be employee representatives on the trustees. It might be that there will be the structure whereby recommendations are made from the company, from an employee group, from an employee council to the trustees. All of that needs to be thought through quite carefully. And from the trustees' point of view, as professional trustees, and I would expect that most people listening to this call are professional trustees, what that means is that there is going to be a need for some quite serious thought to be given to the extent to which, as a first step, the trustee, as a commercial decision, wishes to be appointed to this sort of trust. And I've got a number of clients who are trustees who have just taken a corporate commercial decision. They're simply not going to try to seek this work and would turn it down if offered to them. I don't think that's necessarily the right view. It depends. If trustees are prepared to invest the time to understand the issues, to analyse those and create the appropriate structures, I think that this is a perfectly valid, commercially valid area for trustees to operate in. And I would expect over time that there'll be more independent trustees being appointed, because the other side of the coin is that the benefit that trustees have, corporate trustees, independent trustees, is their independence. While there are all the difficulties that I've highlighted, a professional trustee has one clear benefit compared with the vendors of the company, to the managing director of the company, to employee representatives, which is that the professional trustee is independent. And I think that that means that they have a valuable role to play with EOT type structures, which many EOTs will struggle with over time when they haven't established that independent type arrangement. So I think EOTs is an area to watch and consider and see how things develop. My own view is that it's an opportunity for independent trustees which can be grasped, and I think that that can apply whether the trustee is an offshore from the UK or onshore trust company, from two perspectives. The first is that there's no prohibition from the appointment of offshore trustees to be the trustees of EOTs. Many companies will shy away from that, but there's no legislative prohibition. The second point is that the way that the UK tax rules work, it's not very hard to make a trust UK resident, even if the trust is being run outside the UK. And therefore, if you have a settlor, and we have had several through our office who would prefer the trust to be UK resident for whatever reasons, perception reasons or more substantive, that does not preclude the substantive services being provided by a trustee company which is based and has its administration services based offshore. So I would encourage trustees to look at that and think about that as a potential area for opportunity. Moving on to talk about the Roadchef case. My assumption is that most people on the call will be familiar to a large extent with the Roadchef case. But I thought it was worth talking about it again because I found over the last year or so that I've had conversations with many different companies in different contexts talking about the impact of the case. It's worth just talking about or reminding ourselves what the basic facts were. So the Road Chef case was an EBT established to acquire and deliver shares to employees via a share participation scheme. The chief executive of Road Chef at the time, Timothy Ingram Hill, was appointed as a trustee of the EBT and was therefore unable to participate in the SPS. Ingram Hill resigned as a trustee in April 1988, coincidentally on the last day of the tax year. There was a second EBT which was established and shares transferred from the first EBT to the second EBT. What that meant was that shares became available to Mr. Ingram Hill, who was now a potential beneficiary, and he derived personal benefit from the shares which were transferred. So there are a number of issues. Was the transfer of the shares from the first EBT to the second and the subsequent benefit derived by Mr. Ingram Hill valid or void? And could Mr. Ingram Hill retain the benefits, or would he need to surrender his profits and restore them to the trustees of the first EBT? And the findings after an extended battle in court was that the trustees of the first EBT had breached their duties by benefiting the beneficiaries of the second EBT, rather than being solely concerned with the trust that they were responsible for. That was a breach which operated as a breach of general trust law and the terms of the EBT. It was also found that Mr. Ingram Hill, in acting as a director of Road Chef and trustee of the EBT, had an improper purpose to benefit personally. That means that does not mean he could not properly have been appointed, but that he, in effect, had a conflict of interest in his position. As a consequence of that and the wider factual circumstances, the acquisition of shares by Mr. Ingram Hill was not made in good faith, and as a consequence of that, he had breached his fiduciary duties as trustee. So that was they were the basic findings, and that was quite cataclysmic in terms of being a first decision that I'm aware of with an EBT ESOT type arrangement, where there'd been such strong findings counteracting the actions taken by the trustees. So the question then is, well, one of the questions is, what are the implications for trustees? Well, in many ways, what we have here is a case study in basic trust law, but I think that it was a case study which demonstrates that the basic trust law requirements need to be continually thought about by trustees to ensure that they don't fall foul of them. So trustees of all trusts owe extensive duties as trustees, and that might sound like a statement of the obvious, but it was equally obvious in the Road Chef case that those extensive duties were not fully considered. That includes acting at all times in the interests of the beneficiaries of the trust and avoiding a conflict between their own interests and those of the beneficiaries. Now, if we come back to the points that I was making in the context of EOTs, it is an area where I think that many of the trusts which have established may run into difficulty. Because when you think about the typical fact pattern of an EOT, you will have a vendor, the owner of the company, often the person who founded the company and built it up, selling shares to the EOT and being appointed as the trustee. There'll then be a scenario where the individual concerned in his capacity as trustee will be deciding what payments need to be made to him under the terms of the sale purchase agreement. If he continues to be a director of the company, he will be part of the body which decides whether it's appropriate to make contributions to the trust, which in turn will potentially fund payments made to him for the sale of the shares. It's not very hard to see that there could be a conflict of interest which would be difficult for any person to resolve satisfactorily, and in particular somebody who has been so closely involved with the company. And this is one of the reasons why personally I'm tending to incline towards recommending independent trustees for EOTs rather than the vendors and other people who are closely connected with the company. That the implications for trustees and the requirement for avoiding conflicts also implies a requirement for independent decision making and a full disclosure of potential conflicts. There's an element there of procedure, but procedure is there in order to achieve the substantive goal, the substantial objective of avoiding conflicts of interest and being seen to avoid conflicts of interest, and where they exist, making sure that they are highlighted and a reasoned decision is taken to demonstrate that they did not result in undue influence on the making of the decision. So I think the Rochef case, it is clearly of substantial importance, but I suspect that the wider implications have perhaps not been thought about as fully as they might have been, and they ought to be from the point of view of all trustees, but particular professional trustees, where there would be an expectation of a greater knowledge of these sorts of issues and how they should be applied. That brings us on to talk about the importance of independence. And the case I've referred to here was a recent case, a Hong Kong case, which I read curiously on the plane going out to Jersey to meet one of my trustee clients. And it highlights the need for trustees to act independently and also not to allow their autonomy to be compromised when acting in the best interests of the beneficiaries of the trust. So this has got nothing to do with employee trusts as such, but the points transfer over to employee trusts. The facts were that a Jersey trust, Jersey trustee company, was established for a wealthy family's benefit with the husband and wife as settlors. Between 2005 and 2008, the settlor's wife, described in the judgment as an astute and experienced investor, acted as the trust investment advisor, and in that capacity executed over 500 investment transactions. The bank increased the trust overdraft facility substantially, and nobody queried her investments. Neither the trustee nor the nominee director queried her investment. We then had 2008, and for the people who remember 2008, which I think will be most but not all people listening to this call, 2008 was when the global financial system essentially collapsed. It was the year when stock prices went through the floor, when we had banks which were failing. It is the single most dramatic financial event since probably 1929. And the result was that a lot of these investments that had been made as a result of the astute and experienced decisions of the settlor's wife turned out not to be so astute. And there were substantial losses which were incurred, and the trust then sued for the recovery of those investment losses. What was then found was that the corporate trustee failed to discharge its supervisory duty relating to the trust. In other words, it didn't do its job properly. The corporate nominee director failed to discharge its fiduciary duty to the investment company. The trustee was liable for breach of trust. The nominee was liable for breach of director's duties, and equitable compensation was ordered for the trust's losses. So what this demonstrates, I think, is that being a trustee when things are going well, it's like so many things, is often appears to be relatively straightforward. And it's only when things go wrong that the problems come to the fore and the issues then arise. So what are the implications for trustees? Well, I think the first point is that there is a need to review risk management of trust arrangements, and there's a trap which is demonstrated by the case and other cases as well. If we go right back to the Rangers case, this was part of the underlying issue with some of the earlier decisions with Rangers, not the principle on which the final decision was reached, which is that trustees are entitled and should appoint proper advisors, but they can't abdicate responsibility. And in particular, they can't and should not abdicate responsibility because the person to who they are abdicating is closely connected with the establishment of the trust. The individual here was the wife of the settlor, and that, I suspect from reading the decision, resulted in the trustees not exercising as much care and attention as they should have done. So they ought to be considering the suitability criteria of investment advisors, and for that matter, other advisors, and they ought to implement contractual provisions for allocating risk between trustees and settlors, and thinking about the consequences should investments be made which go down in value or other things go wrong with the trust. But the key point there is that trustees are trustees. They have a duty, they have a responsibility to act independently, and where they appoint advisors, not to just pass everything over to the advisor and do what they're told, but to exercise their duty of supervision, to continue to discharge their fiduciary duties as trustees. So we've covered a fair amount this morning. I hope that you found that interesting. There is the ability to send questions. If you do have any questions, do please email them through to us. On the next slide, we've got the email addresses for myself, William Franklin, Charlotte Fleck, and also our phone numbers. So if you have any questions, do please email and we will respond to them. So thank you very much for everybody attending. I hope that you found it useful, and we look forward to receiving your questions. Thank you.